Starting out, the first course I taught almost 30 years ago was evidence. I followed the book that I used. While it was fine during the semester, when it came time to put it all together and for students to mix the raw ingredients up and create a meal with it, I saw that there were some huge disconnects. So having been a prosecutor, I thought, why not at the end of the course just adopt a trial and have all the students participate, so that before they took the final exam, they would actually have to put what they learned together into a trial exercise. So started it 20 years ago. I've gotten complaints during the semester, a lot of them, and then they transform magically into, that was the greatest thing I've ever done in the context of a regular course. Now, of course, not everyone feels that way, but the students see the value of it after they go through it, and I've kept doing it, and now I've been doing it for a considerable amount of time, and I vary it depending upon the course, the school I'm teaching at. I've taught this course at several different schools, and evidence takes on a new life when it's conflated with trial advocacy. Given that it's a required course, and given that students understand its value, and it doesn't hurt that it's also on the bar exam everywhere, students really take it seriously and want to learn. The problem with evidence is that it is multi-layered. It provides a challenge. And while that's a problem, I also find that to be a great opportunity to use these layers to talk to students not only about doctrine, but the canons of construction. How do you interpret statutes? And this is, for many of them, the first real focused course on statutory construction. Then I find a really important part is how the students transfer their knowledge, because they learn about rules separately, but they need to be able to look at them overall and spot the issue. So even though it's a required course, it involves many of the same skills they've used before. Issue spotting, for example, is a skill they've learned over and over again in first year, but it's really clear here. The one thing I like about that in particular, for example, is when it comes to the final exam, students aren't going to guess. If they try to guess, it's, aha, you have not really gone through the template or the framework that an expert would use in this area. So evidence is the kind of course that lends itself not only to multi-layered parts, but also to frameworks and protocols where students who use that, who gain expertise and transfer their knowledge, learn how to pick, for example, is it impeachment of a witness or is it offer to prove an element in the case? That's a basic dichotomy, and students have to learn that kind of framing. So the fact that it's required, I see as a value for all students. And that's why I think it is required, not only because it's on the bar exam and students should know what it means to offer evidence in court, but I think that the mental challenges for students, the analytics are really, really helpful. Time is always an issue for law professors. How do we fit in substance and depth at the same time, particularly if we use experiential learning? So with the use of that, I have to really make sure I'm using time wisely. And instead of trying to cover every single topic on the surface, I may cut out some topics or give a brief lecture, for example, on judicial notice or presumptions. I will talk about them as subjects, but I'd rather include the trial advocacy. I also have them do things outside of class. I try to flip the classroom, and I have them do written problems. I have them put together directs and crosses outside of class, and I use online platforms like WebCT or Twin or Blackboard and have them post it, so that I'm trying to do all this within the confines of whatever number of credits I have, but I still want to get it done so that 2 weeks before or the week before classes end, I will have these trials. They only do a small part but that's outside of class, and I reserve a whole day, have attorneys come in, or judges, like to have real judges too, and I'll sit in the back, take notes, so that this is one of those feedback loops where I can talk to the students directly, having watched them, and giving them formative feedback because they've yet to take the final exam. So again, I try to incorporate a lot of different things in this. Sometimes it's like looking at that great dessert where you bite off too much, afterwards your stomach's groaning and not feeling good. That's happened to me in the past, where I bit off too much and the students were a little overwhelmed. So it's a balance. How do I get them to do something but not feel overwhelmed, and to enjoy the trial and not feel frightened, intimidated, or negatively about it? I would definitely say try it, number one. No, because I think the rewards are great. I think it also connects to practice. I look at law school classes now as pathways to practice. How do I help them, not just in their analytical abilities, but help them go down the road and be a success and be significant in what they do? So I think using these kinds of exercises and having experiences matters. I would say I would try to start small, that instead of having a full trial, it's great to have an exercise. And it's also good to see one, then do one, and then do it again. So the C one is I would demonstrate first in class a brief direct. Then I would have them all stand up and in groups of twos, have them do a direct on each other and then switch, so that everyone gets a chance to practice in class. And then I'll have, after that's done, one pair stand up for the whole class, and then I'll provide feedback. I don't want the class providing feedback, it's my job. I'll do it in a constructive fashion so that students get to rewind. I think we go through a class linearly, and by the end, the students then have to put it together. I'd rather to stop at periodic points. When you're driving and there's that beautiful scenery, pull out and check it out as you go through it. So this is a chance to stop, have students really look at it, and then move on, so that it's not left right before the trial for them to learn the whole thing. They'll have practice, they'll do it. So that's the basic advice. Then I would also have it structured so the students see the value. You have to explain to the students, this is going to help you on final exams, this is going to help you in your trial ad class, this is going to help you just with clients. You're going to be able to now stand up and talk better. You'll be conscious of your hands. You won't be using both hands or doing all sorts of crazy things, hopefully. And it's about developing good habits. One of the things that I've been interested in lately is the idea of unlearning. Sometimes we go through law school and then realize some students are in trouble and they have to unlearn it. So I'm very conscious of what I want students to learn, and then how I will help them unlearn if they have preconceptions or bad habits. So the way to do this, especially in evidence, is to pick out an exercise, give it to them, do it in class a little bit. So start it in class, have extra sessions for students who do want extra work, but I would do a session together as a group instead of individually. This is all about efficiency and not taking too much time. Have an attorney come in to demonstrate as well. It's always nice having people from the outside, and I like having prosecutors and public defenders. They're very happy to demonstrate. And it does not have to be someone who is unbelievably fantastic. Students should be able to see that it's doable. And so having someone who's good, but maybe not the best ever, students think it might be too easy. When you see someone who's fantastic, they make it look so easy. Students say, how will I ever do that? So I think it's good having those people, but also having some people who are out a couple of years, and you can talk about how they are doing it and what they're learning and working on. And last but not least, when you're done, give feedback and get feedback on it. But I think incorporating it into the course and having it as deliverables where the students are delivering something. Please finish this direct examination. Please practice introducing into evidence something. That's the way to work it. I've started an advanced evidence course now that is almost entirely focused around a trial advocacy problem. They have to do a trial in the class, and their final examination is not an exam, it's actually a motion to suppress evidence. So they're actually writing again, but it's not an exam type thing. It's part of the same trial. So they work all the way through it, they get to embrace it, they get to kick it around, play with it. And that actually worked very well. Students really got a chance to practice and work on their evidence, because I think the first basic course doesn't allow the depth and nuance that they need, but it also allowed them to develop their trial ad skills. So it's been a lot of fun. I happened on this idea where I'd conflate the trial ad and evidence. I think a lot of places and people are starting to think about it. I think it's a great way to teach students, and it's within the Carnegie model. It's within the idea of merging practice and theory. And I think theory and practice are not separate, and this course is a good way to do it. So I'm glad to be able to do it. I'm going to keep doing it, start again in the next semester.